docket. Case number 112250, State v. Smith.
May it please the court, my name is Kevin Zolator. I'm here on behalf of Mr. Smith. I'd like to request 3 minutes for rebuttal, if I may.
3 minutes is granted.
Back in 2006, Mr. Smith pled guilty to aggravated robbery and felony murder. That was April of 2006. In about March of 2014, he filed a motion to withdraw his plea and a notice of appeal. The district court denied both motions. Unless this court would like me to start elsewhere, I would like to start with whether or not the notice of appeal was timely. Typically, a defendant has 14 days to file a notice of appeal. However, there are exceptions to that as laid out in Ortiz. I think probably the best exception for this case that we're relying on is the first, and that Mr. Smith was not notified or fully explained his right to appeal. And I think it's important to look at this under the totality of the circumstances and also in the eyes of Mr. Smith, not as a lawyer or a judge or a justice. And I mean, at the sentencing hearing, all he was told by the sentencing judge was, you may have a right to appeal. You need to talk to your attorney. First, I mean, I don't know how technically we get, but he had a right to appeal. It's not that he may have a right to appeal. You may want to talk to your attorney about whether you want to appeal is different than saying you may have a right to appeal. But I think this is where we get to the totality of the circumstances. If you actually look at the plea, when he entered his plea, no one ever told him, and he was never advised of that by the judge, that when by entering this plea, you're giving up all your rights to appeal. So we can't just assume that he knew, hey, when you enter this plea, all you're going to be able to do is appeal your sentence. That was never told to him at the plea hearing. So then when you get to the sentencing portion, where the judge says you may have a right to talk to your attorney, and then...
That's what happened. He did talk to his attorney, right? And we
Correct.
had testimony from Mr. Falk about what that conversation included or would have included in his usual practice. That's
Right.
what's his testimony. So let's assume that that certainly at the sentencing transcript we have evidence that the judge didn't tell him all of the things we say the judge has to say in Patton. But then we have this testimony of Roger Falk. Well, some of those things I would have communicated. And then the next step is for your client to say, had I been fully informed, I would have appealed.
Correct.
And my understanding of the testimony at the hearing below was that he testified initially, had I understood what was going on, I would have appealed. And then, is that correct?
Yes.
And then there's a follow-up question, and then there's where he indicates, yes, I would have appealed if I knew these things. But the judge, this is where it seems to me you might have a fatal flaw on your Ortiz exception. The judge said, I don't find you credible. He made a specific finding that the defendant, that your client wasn't credible on that issue. Isn't that right?
That he wouldn't have filed an appeal?
Yes,
Yes.
that he wasn't credible on that issue. And if we follow the burden shifting pattern, that's the ultimate question. Would your client have appealed? And the judge said, you testified you would have, and I don't believe you. And we can't undo a fact finding up here. So doesn't that doom you?
Yes, and that's when I said, I think the first exception, or the first prong under Ortiz is probably the best, but I think there's still an overall essence or point to this notice of appeal. You have to be explained what your rights are. You have to understand those. You have to say...
You do, but
and
if having understood them, you have not demonstrated you would have appealed, we've said that's inadequate under the first exception.
I don't know how one makes that burden, though. I don't know how you prove I would have done something. So if the judge had said, yes, you would have appealed, or I find that credible, I mean, obviously it would have been in our favor, and the state would have said,
Well, in this case, the judge went through his reasoning and said that the reason I don't find that credible is because you got a very favorable deal. This and this and this happened. I don't think it's credible that a rational person would jettison that situation and go back to square one. And so I think it was incumbent then on the defendant to show why he would have, even though the judge had found a rational person would not.
Well, and again, and that's when I would go to the.
And can you tell us what compelling reason there would be to have given up, because the court did follow the plea agreement?
Yes.
And why would this defendant have given up the plea?
Well, and I think, I mean, as to why, I can't tell you right now, but when we look at it again, that's the view of the judge or a justice or a lawyer saying, well, why would someone do this?
Except in essence, the judge is saying that the defendant didn't meet his burden of proof on this issue, because we shift that burden in this analysis. And so typically we have a negative finding, standard of review that we apply there. So tell us what the district court ignored in the record of the evidence that he should have considered on this point.
Well, I don't know that the judge ignored it. I just believe it's abuse of discretion when the record demonstrates unequivocally that he was not fully informed of his right to appeal, that he was told there was a hollow right. And that could, I mean, that can make some sense when you're talking about a direct appeal. All you can appeal is your sentence. This was in accordance with the plea. You don't have that appeal. But again, go back to the plea. He was never told that by appealing or by pleading, you're waiving your right to appeal all the other issues. So from his mind, I mean, he's still looking at this as, and again, in his mind, I'm going to do 20 years. I'm going to get out. Mr. Falk also testified that he told him, hey, I think there's a pretty good chance, based on, I think, overcrowding was his reasoning, that you'll get out in 20 years. But that was inaccurate. I mean, even if he had paroled in 20 years, he still had the 55 months on the aggravated robbery. So he couldn't go out in 20 years no matter what. And that's what I'm going to. This is the state of mind of the defendant, of what he thinks is going on. Not, you know, as lawyers and justices and judges, we look at this and we know these terms. We know what it means to do these things. But from his perspective and what he's testifying, it all goes together.
But that wasn't undisputed. That wasn't undisputed evidence of the understanding of the plea, because his mother said, I understood he was going to do a straight 20 and then do something extra for the on-grid, and that maybe 2 years or so with good time credit.
Right.
Which is all sounds real credible to what an attorney probably told him.
Right.
And so it wasn't uncontested what your client said, and the court wasn't required to take that to the bank when there was competing evidence as to what he knew or
Sure.
was told.
And I would respectfully disagree in that I don't know that it contradicts what his state of mind was. Certainly it gives evidence that somebody else might have taken it a different way or maybe had a better understanding. But that doesn't mean that when he says this is what I thought, that his mom thought something else doesn't, I guess, necessarily contradict or rebut what he's saying is his understanding. And I don't think that's refuted. I don't know how you could refute that. But and that's what.
And let's be clear. We're not. Are we dealing with the setting aside the plea agreement?
Well, I mean, we're kind of merging. I mean, the notice, the timeliness of the notice of appeal. I think one of the prongs is, you know, you can file your motion to withdraw a plea so long as you're within your year of the appellate jurisdiction. If the notice of appeal is ripe or timely, then you're still able to file that motion to withdraw a plea. So, if you want me to address it in different arenas.
Well,
please,
I guess what I'm trying to say is, is the standard for the same for both?
Well, the motion to withdraw a plea is manifest injustice.
Well, I know, but one of the factors we deal with is whether he had effective assistance of counsel, and you're sort of arguing that same kind of thing, that he didn't knowingly do this because his counsel didn't. But are we dealing with two different standards?
Well, no, I don't think there's two different. They're just in two different arenas. I mean, under the notice of appeal, we're under the Ortiz exception, and that's why we're saying he did not file his notice of appeal. And we think that falls under the Ortiz exception, which makes it timely. And that is, he was never told by pleading guilty you're waiving your right to all appeal rights. The judge at sentencing told him you may have a right to an appeal, talk to your attorney. And his attorney told him it's a hollow right. Basically, there's nothing to do. So you combine all that, what's a defendant to think? Well, I guess I'm stuck. Then he testifies that later on he realizes, and I don't remember exact words, but he testified as to there was some delay. He hired counsel, and then the motions were filed. Under the motion to set aside, now that's under, manifest injustice, and I think those factors are under Edgar as to was it, and I think under there what we're saying, or main, probably the best argument is that it wasn't understandably and knowingly made. And I think you can see that even at the plea. The judge says, I don't want to misquote him, but something along those lines. He asked for, can someone tell me what the sentence is on this felony murder? And I think the prosecutor says, it's a standard life sentence. And the defense attorney says, it's life with possibility of parole after 20 years. Nothing's really that clear during this whole discussion. I didn't see anything that was admitted into the record that was in writing. It looks to be all oral at the plea.
What exactly is the excusable neglect here?
For the manifest injustice?
Yes.
Well, I don't know that you need
For
it.
the late motion.
Right.
Excusable neglect is a standard for a late motion.
Right.
And I don't know that you need it if the notice of appeal is timely filed, because then I think it's not late. And then if it's excusable neglect, I think, again, he was told by everyone. It seems to me that the judge told him you may have a right, and he was told by his attorney, it's a hollow right. Combining that with, again, at the plea, where he wasn't told when you plea, you waive all your rights, he's going to take that as you've waived everything, you're done, it's a hollow right, not just the sentencing. Because that's when Mr. Falk's talking to him at the end, it's never told to him that because you pled, you gave up all these rights, and now that if you want to appeal on the sentencing, you're only appealing the sentencing. So, I think that's the excusable neglect, is all the misinformation he's given. He's the defendant, and again, he's not an attorney, he's not a judge, and it's different for us. I think we sometimes, we know how these things work, and it's so simplified in our minds that sometimes we might pass that on to a defendant having that ability, but it's not that way.
Just so we're clear here, the motion to withdraw plea was in January of 2014, and the guilty plea was in 2006. We have about 7.5 years delay.
I don't have it in front of me, but I trust that's accurate. And I see I'm out of time.
Any more questions? Thank you, counsel.
Thank you.
Mr. Chief Justice, and may it please the court, Lee J. Davidson on behalf of the state of Kansas. This court should uphold the district court's decision denying Mr. Smith's motion to appeal out of time and his motion to withdraw his plea because while not perfect, Smith was adequately advised of his rights. And I wanted to do the same as counsel did here and take the issues in reverse order because it occurs to me that if Smith does not prevail on his motion to appeal out of time, he loses his motion to withdraw a plea as well. Here's how I get there. As you guys have pointed out, his motion was filed to withdraw a plea was filed out of time. The statute requires that it be filed within 1 year of the appellate jurisdiction terminating. Unless he makes an adequate showing of excusable neglect, and I reread their brief this morning, they don't even argue excusable neglect. So that the only way that they can prevail is if this court rejuvenates appellate jurisdiction by granting their Ortiz motion. There is no excusable neglect. They don't argue it. At this point, I think they've deemed that part of the equation abandoned. So going back to the Ortiz motion, counsel said a number of times that prior to entering his plea, Mr. Smith was not advised that he would be waiving appellate rights. I don't believe that's accurate, with all due respect. In reviewing the record, volume 6, I think it was pages 27 to 30, I do believe Mr. Falk testified that he advised Mr. Smith, this is prior to the plea, that he advised Mr. Smith that he would be waiving most of his appellate rights by entering a plea, but would retain a limited right to appeal the sentence. So I believe Mr. Smith was advised of that going into his plea. Then after the sentencing, this is where we have this divergence of testimony, where Mr. Falk indicated his customary practice was to fully advise him of his appellate rights, but he admitted that he couldn't with 100% certainty say he did so in this case. I will point out that Mr. Smith corroborated that there was a discussion about appellate rights after sentencing, and the district court made a reasonable credibility determination that he simply didn't believe Mr. Smith. And as Justice Beyer pointed out, it's not this court's place to set aside those types of credibility determinations. I think the evidence is fairly clear that Mr. Smith didn't fulfill his burden on the Ortiz exception, and at that point I think we're done. Now I'll go ahead and argue on the withdrawal of plea in case the court doesn't agree with me. It's been my experience that sometimes you guys don't agree with me, so I'm going to go ahead and argue the withdrawal plea. As counsel aptly pointed out, the standard is manifest injustice. It's not defined by statute, but our case laws equated it to something unfair, shocking to the conscience. The standard of review on appeal, of course, is abuse of discretion, meaning generally that if reasonable people would take the same view as the trial court, the court did not abuse its discretion. And as counsel pointed out, they kind of focused in on the Edgar factors. The one that it talks about whether the accused was adequately advised of his rights prior to entering the plea. And they've kind of broken it down a couple ways. I want to talk about those. The first way that they indicate, or they allege, that Mr. Smith wasn't advised adequately was the potential penalties for the crime charged. And I will concede that the district court does have a duty to tell the defendant about the direct consequences of their plea, and obviously the potential sentence is a direct consequence. But the court did that here. The court accurately advised the potential penalties for the aggravated robbery. True, the court did ask for help when advising Mr. Smith of the potential penalty for felony murder, and Mr. Smith's attorney, Mr. Falk, said it's a life sentence with possibility of parole after serving 20 years of that sentence. Dead accurate, correct? Mr. Smith indicated that he understood that. Additionally, Mr. Falk indicated that prior to the plea hearing, he discussed the potential penalties and advised Mr. Smith of just that a life sentence for felony murder means he could serve the rest of his life in prison. He would, however, have an opportunity to go before the parole board after 20 years. Mr. Falk also testified that he had advised Mr. Smith about the fact that the court could run the sentences concurrently or consecutively, and he explained what that meant. And I think I quoted that in my brief, that concurrent means the time runs at the same time. Consecutive means that you serve one sentence, then the other. And you'll notice that in the sentencing transcript, Mr. Falk demonstrated a mastery of the interplay between the on-grid and the off-grid sentence, which lends further credibility to his testimony that he fully advised Smith of his rights. Mr. Falk was obviously conversant in the potential penalties, which makes the district court's finding that Mr. Falk did indeed fully advise Mr. Smith of his rights beyond reproach, I would say. The best argument that Mr. Smith has is that perhaps he wasn't advised that he would be looking at parole for the rest of his life if he were granted parole. Because at the hearing, Mr. Falk testified that while he assumed he told Smith about lifetime parole, he couldn't say with 100% certainty that he did so. But there's that Court of Appeals case, Barahona, that indicates that due process is not violated by failure to advise the criminal defendant of the applicability of a post-release or mandatory parole if the sentence assigned to the defendant in any mandatory supervised period following release does not exceed the maximum penalty term that the defendant was told prior to sentencing. Well, again, here, Mr. Smith was told prior to sentencing life. And whether you add parole to it or not, life is life. So he was adequately advised of that. They talk a little bit about offender registration. The Court of Appeals decision in Legg indicates that the court is not required to inform a defendant of obligations under the Offender Registration Act.
Why is that collateral? I have a hard time getting my head around that. You would agree that anyone that's convicted of a crime that's covered by CORA is going to be required to register without anything else.
Correct.
And nothing additional has to happen. Everyone convicted has to register. Nothing else has to be filed. Nothing else has to be done. That's on the offender to trigger the registration. And it applies to everyone that commit these crimes, but applies to no one that hasn't committed this crime. It's reserved only for those that commit the crime. So why isn't that a direct consequence of the conviction? Logically.
That's a good question. All I can tell you is that our case law says that it's not. The Legg decision, and I checked again last week, Legg still remains good law.
From the Court of Appeals.
Right. This court had an opportunity to review that decision and declined. The other thing that was briefly mentioned in their brief was this notion that the defendant didn't understand what was going on because he was on some prescription medication. I think the Denmark-Wagner decision of this court kind of handles that the statutes don't require the district court to ask about specific medications, although it's probably a good idea. Unless there is some indication that the defendant is on medication at the plea hearing, and in those cases, the court must make an on-the-record inquiry about the possible side effects. Here, Mr. Falk testified he had absolutely no concerns about Mr. Smith at the plea hearing. And if you'll recall, prior to the plea hearing, Mr. Smith made a proffer in an inquisition, and I believe that testimony is part of the record here. And his testimony was pretty remarkably detailed. It showed good memory. There was no indication that he was under the influence or that if he were on prescription medications that they affected him in any sort of way that would inhibit his ability to understand the plea process.
That was right before, is that how the sequence was? He
Right.
did the Inquisition testimony, which was part of his plea deal, and then stepped right in and did the plea. It was one after the other.
One right after the other. That's right. In a nutshell, I would agree with counsel that the plea colloquy here was not perfect, but the law does not require perfection. Failure of a district court to perform a flawless colloquy does not constitute something obviously unfair or shocking to the conscience, which is the burden that Smith must show here. He didn't do that. I'd ask the court to affirm the district court's denial of his motion to appeal out of time and his motion to withdraw plea. There's no other questions.
Any more questions? Thank you, counsel.
Thank you, Your Honor.
You reserve 3 minutes for rebuttal.
Thank you. And I'm not sure, and I have to go back, and I had the record, but I wasn't able to find where counsel was speaking that Mr. Falk advised him that he was waiving all of his rights at the actual hearing, basically testifying that he had done that back in 2006. But I still don't think that changes the analysis of Ortiz, and I think the essence of Ortiz is basically your time doesn't start to run until you know you've been explained your right that you have the right to an appeal, and you basically choose not to appeal. That's when your time starts to run. And the cases don't say that, but I think if you look at it, that's got to be the underlying principle behind them. And here, again, the judge told him, you may have a right, talk to your attorney, and then his attorney says it's a hollow right, basically there's nothing to do. I don't think that is enough to start and to trigger the timing or the days to file the appeal. So we do think that that tolls it, and that, I guess that'd be the word, under the first exception. Or if you just look at all three or T's in general, he wasn't fully made aware of his right to appeal. And so that's why we think it is timely. And then counsel talked about, and I didn't get a chance to talk about, fully the understandably made. But those are the two primary issues that we raised, are that he was not told that he was going to have to register, and the lifetime parole. And when we're talking about this again, I think it's not in general or what we think or looking back at, is what did the defendant know at the time? Did the defendant make the plea? Was it understandably made? And what we look at is typically, I guess, not from lawyers saying what they talked about him in the back room or at their office, but more, look at the record and what is the judge in the trial court explaining, and what's the dialogue. I think that's the best evidence of if there is an understanding, and I just don't think we have that here. So we'd ask you reverse the district court on both rulings.
Let me clarify, what are we talking about? Whether he would have appealed what? Appealed his sentence? Because
Yes.
we know he can't appeal his conviction. You agree with that? It's only a limited right to appeal if you enter a plea.
Legally, yes.
And we do have a statute that says if you have an agreed upon sentence that the court accepts, that's not appealable, right?
Well, and I don't know if it's not appealable or if you just can't win. And I don't know. I mean,
Well, there's a statute that precludes appellate review of a sentence that's agreed upon and accepted by the court.
right.
And so I think at the very least, wouldn't the defendant have the obligation to at least set forth what the complaint would be on appeal?
Well, then if you take this in the context, if you have a trial court and this is where this is happening, if we were to go down that road, I think it's dangerous. You're going to have the trial court then deciding whether or not it's timely, and then deciding whether or not there was an appealable issue, which is what the appellate court's supposed to do. And when you say that the appellate court,
I'm not saying the appealable issue. I'm saying something for the defendant to complain about, whether that rises to the level of a appealable issue. But there's got to be some complaint.
and I understand, and what
His complaint now, as I hear it, is the denial of the motion to withdraw plea, and that denial was right then, and so I don't understand what he needed to know about appealing that.
Okay, and I'm not sure I'm understanding. Let me try to answer what I think you were saying. If you appeal a sentence and it's agreed upon and it gets to the appellate court, I think they deny it, but they have to review it to make that determination that it was an agreed upon sentence. So I don't think you're precluded from filing the appeal. You just, that's a discussion about the merits. And the only question I think presented here is whether or not he could have filed, not whether or not it would have been valid or he would have won or appealable. I think it's just the procedural, did he have the right to file it, if that makes sense, if I'm answering your question.
And then, if what I hear you say is, yeah, he could file it, and it would get, he'd lose because there's no appealable issue, then why wasn't the alleged advice that it's a hollow right absolutely accurate?
Because, I mean, in order to even, I guess I need to back up. In order to even file the motion to withdraw plea, even get those on appeal, I think you have to file the notice of appeal regardless. So you'd have to file the notice of appeal and then file the motion to withdraw plea as well. And so I think when the defendant is saying, I would have filed it, I mean, we're looking at it again as lawyers and justices and judges, what we mean by that. But I think what he means by that, or what we should take from him by that, is I'd want to fight what I thought was going to be a 20-year sentence. And so my lawyer, I would have told them what I wanted to do, and they would have, of course, told me that you need to file a motion to withdraw a plea, which is what happened here. And so, and I know I'm kind of changing your question, but trying to answer in the best way, again, from the defendant's perspective, not from our perspective, what we mean by I would have filed an appeal. And again, that's why I went back to, I didn't see at the plea stage where he was told you wouldn't be able to appeal those other issues. But if it's in there, I trust my friend over there was accurately saying that. So,
Any more questions? Thank you, counsel.
thank you.
Thank you both for the arguments this morning. Court will take this matter under advisement